some buckling and peeling plaster around the corner of a window frame in the family room, and stains on the ceilings in the family room and the kitchen. Upon inquiring, Mrs. Davis was told by Mr. Johnson that the window had had a minor problem that had long since been corrected, and that the stains were wallpaper glue and were also the result of some ceiling beams being removed. There is some disagreement as to whether he did or didn't say that there had ever been any problems with the roof or the ceiling, but he did make those representations that the stains were glue and the window had long ago been fixed. So the Davises thereafter paid the remainder of their deposit. Johnsons moved out of the home. Several days later, following a heavy rain, Mrs. Davis entered the home and discovered water gushing in from around the window frame and the ceiling of the family room and the light fixtures and the glass doors and from the stove in the kitchen. So, the Johnsons, broker, got 2 roof inspections for him and said that for under $1,000 they could fix the leaks in the roof and then the roof would be watertight. And they were going to be obligated to make repairs anyway. But 3 roofers hired by the Davises said that the roof was fundamentally defective, that any repairs would be only temporary because the roof was slipping, and that only a new $15,000 roof could make the home watertight. Slipping, in case you don't know, it's tiles on a roof sliding down. They're not locked into place sufficiently, and they're coming down, and there's nothing going to shove them back up and make them stay. So the Davises filed a complaint for breach of contract and fraud and misrepresentation, and sought rescission of the contract and a return of their deposit. The Johnsons counterclaimed. They said they wanted to keep the whole deposit as liquidated damages. I hope all the buzzwords I just used here ring a bell with y'all. Liquidated damages, rescission, fraud, misrepresentation, breach of contract. So they had a trial, and a year later in May, the trial court made no findings of fact, but awarded the Davises, gave the buyers their $26,000 additional deposit back, but said, Johnsons, you can keep the first $5,000 deposit, and that each party was to pay their own attorney's fees. Candidly, anybody could look at that and say, that just makes no sense at all. If there was fraud, you don't get to keep part of the deposit. This is like splitting the baby. Oh, you keep some, and you each pay your own attorneys. When we'd agreed we're going to have prevailing party attorneys. So it's kind of like, duh. The ruling was so bad that both parties appealed. Buyers wanted all their money back. Sellers wanted to get to keep all the deposit. So, the appellate court of Miami, this is the 3rd District Court of Appeal, found for the Davises the buyer. So they agreed, yeah, keep your first deposit and get back your $26,000 additional deposit, and you get to collect attorney's fees. In other words, Davises win completely. Rescind the contract, get back all the money you spent, and get your attorney's fees. All right. Of course, Johnsons didn't like that, so they appealed, and the Supreme Court took the case. And this is the opinion of the Supreme Court. And what you're going to see here, interestingly, just talking about court opinions in general, usually court opinions are very limited. You always hear about the Supreme Court ruling on just the one little point they have to rule on, but they don't touch all the other areas. What you're going to find here is that the facts of fraud sounded pretty clear. And it sounds pretty clear what should have been done. And like the appellate court did it right. And so the Supreme Court is initially saying, yeah, we agree with that. But they're going to go on and rule some more stuff that makes it important, and that's what I want to talk about. But I want to say first, the court said that in Florida, there are 4 elements that need to be present to have fraud. Because the court is going to agree, yeah, there was fraud. So I want to tell you the way the Supreme Court said, and this is a landmark case, and this is still a law in Florida, and it's cited by courts going forward all the way since this ruling, that there are 4 tests for fraud. A false statement concerning a material fact.
You said confirming?
A false statement concerning a material fact. So that's the material part we talked about before. Secondly, the knowledge by the representor, they call them. The knowledge that the representation is false. In other words, intent to deceive. You knew it was false. Number 3, this is the one little tweaking thing. An intention that the representation induce another person to act upon it. So we talked about reliance and all earlier. What the court is saying here in Florida is an intention by the person who's making this statement that it be relied upon. I'm making a false statement, and I hope you'll rely upon it. I want you to rely upon it. And then lastly, the court says, number 4, injury by the party acting in reliance upon it. Not just the intention that there be a reliance by the person who made the statement, but then actual reliance by the injured party. So the court is really saying the same things as the 3 tests we talked about before. Intention, reliance, and material. And they just saying them a little different, but in Florida they cite it as 4 tests. But it really is covering all the same concepts. The only little tweak is in Florida, the intention that it be relied upon is the only slightly different concept from the 3 tests discussed in the book. Now, the court goes on to talk about historically what's necessary when there's fraud, gives a bunch of examples, talks about, and then totally shifts gears, and this is the interesting part about it, totally shifts gears into not just what did you say, but what did you have to say? We're now going to shift this concept beyond making a false statement. The court's now going to talk heavily about silence and about failure to make statements. And we talked about that before, that fraud can be imputed from silence, from not disclosing something, not necessarily active concealment like let's go plaster it up and paint it, but just plain old not saying anything about it. So as you're going to see, Florida Supreme Court is going to impose an obligation to disclose certain things, not just, and call that fraud, and not just hold you responsible for making a misstatement. Although the court did find there was fraud here, the seller did say the window had been fixed, it's fine, and the stains were just glue. Those are lies. That was actual fraud. But the court's going to now go on and talk about what the seller was actually required to say and required to disclose, even if Mrs. Davis hadn't asked. Okay, so the court reviews a bunch of cases historically, and all of its prior rulings on what it called caveat emptor, let the buyer beware. And the court says, and this is just some nice legalese, after reviewing about a dozen cases of factual things about a bad swimming pool or a bad roof, and but where no statement was made, where sellers had said nothing, and the court had previously said, that's okay. As long as you don't lie about it, you're fine. Well, the court says, these unappetizing cases are not in tune with the times and do not conform with current notions of justice, equity, and fair dealing. One should not be able to stand behind the impervious shield of caveat emptor and take advantage of another person's ignorance. Our courts have taken great strides since the days when judicial emphasis was on rigid rules and ancient precedents. Modern concepts of justice and fair dealing have given our courts the opportunity and latitude to change legal precepts in order to conform to society's needs. Thus, the tendency of the more recent cases has been to restrict rather than to uphold the doctrine of caveat emptor. The law appears to be working towards the ultimate conclusion that full disclosure of all material facts must be made whenever elementary fair conduct demands it. So, then the court cites a bunch of progressive cases, mostly in California, and a few in Illinois and Nebraska and West Virginia. Citing cases means we talk about these other cases and the results, and this time we're saying we like them. So here is the punchline that I told you about a holding in a case, and this is the rule in Florida now. And the court says, we hold. You see those words in a court opinion? That's how you know this is the holding. We hold. We hold that where a seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose those facts to the buyer. The court says this duty is equally applicable to all forms of real property, new and used. So we're not talking about just a builder, we're talking about resales, 3-year-old homes or 50-year-old homes. But we are talking about homes, and I want to be sure that the courts have made that very clear since then. The seller of a home. This is residential. This is not commercial. This is not any building, any property. This is a residence. So let's go back through those high points for a minute. Where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose. So this is not about the buyers asking questions and lying. This is not about just plain old on your own telling a lie. This is silence. This is saying nothing. And the court says no. You're under obligation on your own to disclose. Now, interestingly, though the court approved the holding of the appellate court, saying, of course that's right, give them all their money back, and give them their attorney's fees. But there weren't any damages yet. Remember, damages are what they wrote checks for. But I mean, they hadn't bought the house with a bad roof. So it's not a question of let's award them the $15,000 for the bad roof. They're not buying the house anymore. We're rescinding the contract. It's before the closing. Okay, interestingly, there's a dissenting opinion, which is kind of well written, which is Justice Boyd, who was there for a long time and is real conservative, and he just says, I strongly disagree with the court, and this totally changes the law. Yeah, it does. And the majority of the court wanted to. It's interesting what's happened since then in Florida. There have been cases since where the Supreme Court has talked about Johnson versus Davis and has gone even further to explain. In another case, the court said, even though the falsity could have been ascertained if investigated, doesn't matter. In Johnson versus Davis, they didn't talk about it in the opinion, but that's why it was relevant, that there was a roof inspection clause. And before closing, buyers were going to get to have a roof inspection. They can get that far. But the court's saying the fact that the buyer could have found out is not relevant. Seller, you're obligated to tell them. Second one, interesting comment. There is no requirement of fraud or negligence. There is no need of proof of seller's intent here. You don't have to prove that the seller tried to deceive you. The court said the forgetful seller is just as liable as the fraudulent seller. You don't get to say, gee, I didn't mean to hurt these people. I forgot to tell them. Well, that's too bad. The court says, if you're a really nice guy and you didn't intend to hurt anybody, well, that's too bad. You're just as liable for damages as if you're laughing to yourself thinking, haha, they didn't see this. It's interesting that the court created what the trial lawyers call a whole new cause of action. We used to just have lawsuits in Florida for fraud. We now have a cause of action that lawyers call a Johnson non-disclosure case. And this is no requirement to prove those elements of fraud. Simply, seller, it was your job to tell me. And you didn't. End of story. In a 1990 case, the Supreme Court said that the as-is provisions pre-printed in the bar contract don't overcome this obligation. You can have as many as-is exculpatory, as we talked about, clauses as you want, where it says seller's under no obligation to disclose anything. Doesn't matter. The court says you are under the obligation to disclose these types of things. Material, effects value, not readily observable, not known. Doesn't matter what your contract says. You cannot contract your way out of this obligation, is what the court's saying. Okay, but there have been several cases that have said very clearly that this does not apply to commercial property. But that gets a little interesting. What's a commercial property? Duplex? Quadplex? Eight-unit apartment building? At what point does it become a commercial property? What if it's a 6-unit apartment building and the seller lives there? Is that residential? Is that commercial? The courts are clearly saying it doesn't apply to a shopping center or an office building. But what about residential property that may be multi-unit and in fact the seller does live there? Courts said, and so that hadn't been tested yet, is what I'm saying. So I wouldn't take any comfort here if I were selling a duplex and say, nah, that's not a home, I'm fine. Okay, that's the end of the chapter on fraud. I hope you'll take a look at Johnson versus Davis. I think you'll find it fun reading, actually, and very well reasoned. And but it was a big step because it was no longer the traditional seller's got to lie. It was a whole new area of seller's got to spill his guts. Got to tell them whether they ask or not. Okay. 12 o'clock. We got 2 more chapters to cover. You all want to break for lunch? Or you want to do a chapter that I think involuntary liens? Now that's going to take a while. What do you want to do? That'll probably take an hour. You want to do the next chapter, or you want to go to lunch?
Lunch.
Somebody,
Lunch?
anybody?
Lunch.
Nobody cares?
They don't care.
I'd rather cover this chapter quickly if it suits y'all, unless somebody's starved, because the last chapter we're going to get into is going to involve us pulling out the materials that I sent you and getting into some stuff pretty much in depth. And I think that might be a stretch. Let me just go through quickly chapter 14, which is called involuntary liens. Chapter numbers are a little weird here in the different editions of the book. It's chapter 14 in this 8th edition. The reason is, beginning of chapter 14, the prior editions move some chapters around. The name of the chapter is involuntary liens. Here's what a lien is. A lien is a claim against another person's property for payment of a debt or for the fulfillment of some other monetary obligation. Now, the person who has a lien is a lien holder or a lienor. But here's what's important. This lienor, lien holder, does not have title, never gets title, does not have possession. The things we talked about before. Doesn't own it in fee simple. Doesn't have the right to possess it as a lessee or a life estate. It's not an estate, it's not a right to possess, it's not even an easement, it's not even a right to use property. It's a right to have a piece of property sold to secure a debt, to pay a debt. You're not the owner, you've got a claim against the owner and a claim against the owner's property. That's an involuntary lien. Now, actually, that's a lien. We got voluntary liens and involuntary liens. This chapter is involuntary liens. A voluntary lien is pretty easy. It's a mortgage. The owner signed a document to put a lien on his piece of property. He intended to create a lien on his property. That's a voluntary lien. Another story, another chapter, another subject. This chapter is involuntary liens. The owner of the property did not intend for whatever is happening here to create a lien, but it happens to him anyway. Okay, we're going to have 4 kinds of involuntary liens that we'll talk about. 5 kinds, excuse me. But let me just get, this is real overly simplistic, but we've got a piece of property, a piece of vacant property in this case, and it's owned by the owner. Owner owns this piece of property. Now the first type of lien we want to talk about is a mechanic's lien. A mechanic's lien is a lien in favor of, the lienor is going to be somebody who renders services or supplies materials in connection with the improvement of that piece of property. Simple. It's the contractor who's going to build a house. Or Causeway Lumber that's going to deliver lumber. It's the right of that person, the lienor, to have a judicial sale of the property to satisfy his unpaid claims. Now let's talk about the parties to a mechanic's lien and how this really comes about. And there are a bunch of tests, and we're going to go through the tests to see what does it take to have a valid mechanic's lien. But let's talk about how this can happen. Owner decides to build a house, and he signs a contract with the contractor. So he signs a contract I'll pay you some money, you build me a house. Okay, pretty simple, pretty straightforward. If contractor builds a house, owner doesn't pay him, contractor gets a lien on the property. But it goes a lot further. Contractor usually hires a bunch of subcontractors, a plumber, an electrician, a roofer. These people don't have a contract with the owner. They only have a contract with a contractor. Contractor says, you do the work on this property and I'll pay you. Owner doesn't know who they are, doesn't have any contract with them whatsoever. He's only got a contract here. So we're talking about, as a lienor here, people who could file a lien if they don't get paid. Not only the contractor, but the people he hires, the subcontractors. Or maybe the material man. This is the guy who's going to supply concrete, lumber, pipe, who's going to deliver materials to the property, and they're going to be incorporated into the house. But still, owner doesn't have a contract with this guy. Only this guy does. Or maybe even only the plumber does. Maybe the plumber was going to buy his pipe from this guy. So it could be several steps removed. The material man would never be contracted with the owner. But he might be contracting with the general contractor, or he might be contracting with one of these subs. All these people can have a lien on the property, a mechanics lien. And maybe the owner did contract with some other people though. He might have contracted with an architect to design the house. Maybe. In that case, the owner has a direct contract with that guy. He can file a lien if he doesn't get paid. Or maybe it's possible the owner hired the contractor and said, you find an architect. In either event, architect's going to draw plans to build a house, to improve the property. Architect has a right to file a lien. So these are the types of people we're talking about. Engineers, architects, surveyors, etc. These are the type of claimants who might possibly have a mechanics lien. It's required in order for a mechanics lien to arise that the person who is contracting for the work at some level, either with the contractor or with the architect, has to have an ownership interest. He has to own the property in order for a lien to arise. In other words, if I sign a contract to build a house on your property, the people who don't get paid don't get a lien, because I didn't own your property. Now this owner could only own the life estate. Hell, maybe he's only a tenant under a lease. But he has to have some interest in the land that's going to be improved in order to create a mechanics lien. What we're talking about here is people who work on the property and then don't get paid. There has to be some connection somewhere with an owner that owned the property in order for a lien to arise. The type of work we're talking about has to be an improvement. And all that means is things that you might not think about as sticks and bricks, as we usually call it, but not just sticks and bricks. That's why you bring in people like a surveyor, an architect. They didn't put any stick, they didn't deliver any materials, they didn't build anything. They push papers around. But it counts. Yes, sir.
So you're basically saying two things.
I'm sorry, what?
The contractor has to make sure that he's actually signing a contract with someone with.
Someone with an ownership interest in the property.
With an ownership interest in the property.
Right.
Okay. And the second thing is, the subs
Yeah.
can go around the contractor even though they have a contract with the contractor.
That's what we're going to talk about.
Okay.
We're going to talk about how they can end up with a mechanic's lien, even if they didn't contract with the owner. That's what this is all about.
Okay.
What if the plumber doesn't get paid?
Mhm.
What can he do about it? Theoretically, he can, of course. Of course he can sue the contractor if he wants to. But what he'd rather do is have a lien on a piece of property and get paid. That's what we're going to talk about. That's what a mechanic's lien is. The right for somebody who improves a piece of property to file a lien against that property to get paid. You did the work, you improved the property, you're entitled to a lien to make sure you get paid. That's what this whole topic is we're talking about. But now we're talking about the requirements of it. But that's why I drew this. I wonder if you don't understand that concept, then the rest of this stuff is Greek. It's somebody who worked on a piece of property and doesn't get paid, gets a lien on that piece of property in order to force the sale of that property so he can get paid. If you don't understand that, you might as well quit listening. I don't mean that to be smart, but the point is, you got to be there because it's going to get much more complicated from here. You worked on a piece of property, you improved a piece of property, you didn't get paid, you can have a lien on that piece of property to ask the court to sell the property to generate the money to pay me. That's what this is all about. Okay. All right. There has to be a contract
What
with
was
this owner we talked about. Yes.
What was the second requirement?
I'm sorry?
The second requirement?
I'm sorry. Of second of what? You mean of the several we talked about? The owner has to own an interest. Is that the second maybe?
What was the first one?
That was the first. Okay. Type of work has to be an improvement of the property. I'm sorry, I don't have these numbers, so I wasn't sure how they were coming out. Yeah, the type of work we're talking about has to be an improvement in the property. Okay, there has to be a contract with this owner by somebody. Somebody has to have a contract with the owner. In other words, the owner whose property is going to get liened has to have a contract with somebody to have the work done on his property. That's why, as I said, if I enter into a contract for somebody to improve your property, well, there is a contract, but I didn't own it, so it can't create a lien on your property. But there has to be a contract between the owner and somebody. Architect, direct maybe, or contractor. It's even possible, and this happens often. This guy says, my friend Joe's the plumber. General contractor, I cut out of your contract the plumbing. I'll contract with a plumber direct. I'll get the plumbing done, he's my friend. He could contract with a plumber if he wants to, in which case there would be a contract. The plumber would have a contract. The plumber wouldn't have a contract with the GC. Contractor we're talking about here is the GC. You always hear about it, the general contractor. That's who this guy is, the GC. And these guys are all called subs. What that means, of course, is they don't have a contract with the owner. They have a contract with the GC. In this case, this guy's not a sub anymore. He has a contract with the owner. This doesn't happen very often. Usually you hire a GC and say, you do it all. Use all your tradesmen, you get it done. But occasionally, owner could conceivably carve out certain parts of this work and not have them be part of the general contract. But there has to be a contract. Somebody has to have a contract in order for a lien to arise. The materials talk about there has to be consent by the owner. If perhaps a tenant is who contracted for the work. People contracting with a tenant could only file a lien on his leasehold interest. Right? So it interests these guys. But under certain circumstances, the owner can be deemed to have consented. The owner might have entered into a ground lease with this guy. You remember we talked about under a ground lease, the tenant builds the building? Well, then it's pretty clear that the owner knows that the tenant is going to build a building. And therefore, the owner has then consented to these guys filing liens on his interest in the property if they don't get paid. So the owner, the point being simply, if a tenant who didn't have a ground lease went out and contracted for some work and the owner never knew about it and didn't consent to it, then his fee title can't be liened. Okay. Now, the type of improvement we're talking about, this should have been, this was poorly organized in terms of the order in the book. It has to be a permanent improvement. That means there has to be a permanent benefit to the land created by whatever type of work resulted in the lien. The best example I can think of is that mowing the lawn is not a permanent benefit, but laying sod is. Planting bushes, that's a permanent improvement. Taking care of them, fertilizing them and trimming them, is not. We're talking about here a permanent benefit to the land. Okay. Universally, all states, there are two important steps that have to happen in order to what's called perfect a lien. In order for the lien in favor of these guys who don't get paid to be perfected, two things have to happen. Number one is called a notice to owner. The owner, under our situation here, doesn't even know about these guys. Doesn't care, doesn't want to know. All he wants to do is to pay the contractor and get his house built. He has no idea if there's going to be an electrician or who the electrician is going to be. In order for any of these guys, or the materialman, to have a lien, they have to send a notice to the owner. They send a notice saying, Mr. Owner, I have a contract with your GC. I'm going to do work on your property. If I don't get paid, I'm going to file a lien on your property. That's what a notice to owner says. That's the notice to owner. Okay? In order to have a lien, the sub has to file a notice to owner. Now, this guy doesn't. This guy doesn't. On our example, he doesn't. These people have a contract with the owner. He signed a contract with them. Of course, they don't have to tell him, hey, I'm preparing some architectural plans for your house. Well, of course you are. I hired you to do it. You don't have to send a notice. Only a subcontractor who does not have a direct contract with the owner has to file a notice to owner in order to have a lien. And it makes sense. The other guys have a contract with the owner. Okay? The second thing it has to do to file, to perfect your lien, is to record it. That's later. Notice to owner is early. Notice to owner is in Florida within 45 days after they set foot on the job. You don't need to know that. But the notice to owner comes early on. I'm going to be working on your property. Make sure that I get paid. Okay? Secondly, later, when they don't get paid, they have to record what's called a claim of lien. I thought back on, and I feel badly about this. Chad, you asked me in an earlier class, Well, what does record something mean? And this is something that I so take for granted that everybody knows what recording means. We have a chapter on recording coming up next week. Basically, all documents that affect the title to real estate get recorded in the public records. You used to take them to the courthouse, now that's in a different building. You take them downtown to the governmental center. Every county has a recorder where you record documents. And we're going to talk about that at great length next week, what it means and why. But the point is, there's a certain place where anything that you want to do that affects title to real estate, a deed, a mortgage, a claim of lien, when you record something, you walk into the recorder's office and you pay him a fee and say, put this thing in the public records. And the purpose of that is, basically, it's notice to the whole world of your rights. It's notice that I bought this house. It's notice that I loaned you money. I have a mortgage on your house. It's notice to the world here. You don't record this. You just say, hey, owner, I'm going to go working on your house. But when he gets stiffed and you don't get paid, then you go record a claim of lien in the public records. And only then, at the end of all this, can you, with a claim of lien, if you still don't get paid, there are a lot more hoops to jump through. If you still don't get paid, in theory, what we're talking about here is you, as the electrician who didn't get paid, can file a suit against the owner and get the court to sell that piece of property to get you paid for your electric services. That's what this is all about. Okay? But the lien is no good unless you did file a notice to owner within the period required by the statute. That's different in every state, but in Florida it's within 45 days after you set foot on the job. See, the owner ain't living here yet. He doesn't know who the hell the electrician is. He didn't have to drive by every day and see who's working on the property. So you had to tell him. And what you're telling him is, I'm working on your property. I expect to be paid. If I don't get paid, even though you're not obligated to pay me, the GC is, I want you to know that I'm doing electrical work on your piece of property. And if I get stiffed, I'm filing a lien on your piece of property and asking the court to sell it to get me paid. So, what do? If you're the owner, you make damn sure he gets paid. And that's what this is all about. Making sure the subs get paid. Or the material man who brought in the wire and the electric conduit pipe and all the stuff, you know? Okay. Now, here is the most important thing. It's one paragraph on page at the end of the mechanics lien section. There's a paragraph that is the most important part of this whole story. And it talks about the Pennsylvania rule, which is in the minority, but that's the rule in Florida. And it talks about the New York rule, which is the majority, and that's not in Florida. Florida follows the Pennsylvania rule, and here's what this is all about, and here's what it boils down to. And I'm going to tell you how, but here's the bottom line. If you're the owner, you can end up paying twice for getting your house built. If you don't follow the mechanics lien law as the owner, you can pay twice. And here's how. Very simply. You paid the contractor, and he stiffed the subs. And they all sent you a notice to owner, and they told you, you better make sure I get paid. And you don't make sure they get paid. You go ahead and put blinders on and say, oh, that's cool, well, I have a contract with him, I only have to pay the GC. Not so. You got a notice to owner from the electrician. It's incumbent upon you to make sure the electrician gets paid. So what this is all about is, in Florida, you can sit back and stupidly pay all your money to the general contractor. and then he stiffs all these people, and they all file liens against your property, and then you pay them a second time for the same house. And that's why following the mechanics lien law in Florida is so hugely important. This is a very complex area of the law. There are people who specialize in it, do nothing but it, both representing owners, defending themselves, representing subs, making sure they get paid. Because we're talking about big bucks. Building a $40 million office complex. The electrician may have a $3 million subcontract there. Wants to get paid real bad. Just so you know, generally how these things work, owners pay contractors in stages of completion. That's usually what a construction contract, how it works. Stages of completion. 20%, 40%, 60%, usually is that, and then a final payment. Each time a payment is due, a 20% payment is due, you say to the general contractor, I'm not giving you your 20% until you bring me a release from every sub who's filed a notice to owner to me. Because otherwise, you pay him, he stiffs them, you're going to get linked. And you do it again at the 40% draw, and at the 60% draw, and at the final draw. Every time. Now, you don't need a release from the roofer who never filed a notice to owner. You get to say, I don't even know there's a roofer. I didn't see a roofer. I didn't deal with a roofer. I didn't get a notice to owner from any roofer. I don't have to worry about a roofer. But you sure as hell have to worry about everybody who sends you a notice to owner. That's a notice to the owner, I'm going to be working on your property, and I'm going to sue you and lien your property if I don't get paid. Make sure I get paid. That's what it's all about. And the legislature had designed this law. This is what this is all about, is making sure that subs get paid.
And when does the owner ask for a release?
I'm sorry?
When does the owner ask for a release?
When does he ask for a release? Each time he's making a payment.
So as he makes the payment, he gets the release?
Yeah.
Okay.
And sometimes if the GC is not getting along with the subs, sometimes the GC will allow and the sub will require, in order to get a release, that of the $30,000 you owe the contractor in this draw, the electrician may stand there and say, I want $7,000 of that. I'll give you my release then. I'm due $7,000. You'll get my release. Take it off what you owe the contractor. And the owner will do it to get that release. Now, if the contractor says, no, I'm not happy with the electrician, don't pay him, then you got to fight, then you got to break down on the job, then you got to hassle. But what's interesting is when you get into really big business, this is way beyond the scope of what we're talking about, but I want you to realize the leverage between all these parties here. The GC is powerful enough, strong enough. Stiles Construction, for example, and I love Terry Stiles, but somebody big, okay? The GC who's big and strong enough says to each of his subs, if you file a notice to owner, you'll never do another job for me again. So don't file a notice to owner, okay? So you got all this pressure here, him saying, I want all the money, I'll handle it. Telling his subs, you better not file a notice to owner. Because I don't want to go through all that hassle of having to get a release from you every time we're going to get paid. Trust me, I'm big, I'll take care of you. Maybe you will, maybe you won't. But that's the pressure on the little guys. And so this guy, yeah, he files his notice to owner, and he gets paid in this deal, but he never gets hired by this GC again. So there's a lot of give and take and leverage and at work here. But the law is designed to protect this guy if he goes through these steps to make sure that he gets a lien on the property to get paid. But it ain't that simple. I mean, it is that simple, but it's more complicated. The bigger the bucks get, the more the leverage is. And they say, if you ever file a lien against on one of my jobs, even more so, I'll make sure you don't work for me again, and I'll make sure you don't work for any of my buddies again either. You don't ever lien one of my jobs. And I'm not saying that about Terry Stiles. What I'm saying is if a good, big, strong contractor who doesn't give a crap which electrician he uses. He'd be glad to use somebody else on the next job. Don't you ever lien one of my jobs, that damages my reputation, that's in the newspaper, you know, such and such a job has 6 liens on it, and so was the general contractor. That ain't good for the general contractor. So those 6 people never get jobs with him again, and he tries to make sure they never get another job in the county if he can. Questions? Yes?
Yeah, so is a lien waiver or a partial lien waiver same as a lien release?
It's the same thing, yeah. A partial lien waiver is a release for payments up through the date of that payment.
Okay.
The electrician may have some more work to do,
Yeah,
you
yeah.
know, but at that point, if $30,000 is due the GC, maybe 7 of that is due the electrician.
Mhm.
So you get a lien waiver from the electrician for all services due through the date of that payment.
Okay.
But that doesn't kill his lien. His lien continues until he gives a final release at the end of the job.
Okay.
What usually happens, even if you don't do this at stage of at these stages, at the very back end, nobody ever who has this much of a brain makes a final payment to the contractor unless every single sub has submitted his final release. You hear about holdbacks on a job. In addition to these 5, 20% payments I talked about, there's always a holdback. And of every payment, usually of every payment, 10% is held back into a final fund. So that even after you do your 5 stages of completion, there's a 10% reserve back here that they make very sure that everybody's finals are in. So I mean, there are all kinds of ways to protect the owner and for him to protect himself, and for the contractor to try to protect himself. And remember that if the owner doesn't pay the contractor, well, of course the contractor can file a lien. But then, all these subs are going to be filing liens too, because they ain't get paid. But they may have gotten talked into not filing a notice to owner, in which case they ain't filing liens. They can file them if they want, but they're unenforceable. They're not valid. There are all kinds of periods, and of course, all of these things tie up the title of this property. Liens are filed, stuff like that. Once liens are there, there's a certain period for anybody who files a lien has to file suit within a year, or it's gone. But there's so many wrinkles to this. The owner can file a notice of contest that says, okay, you have 30 days to file, and if you don't file within 30 days, your lien goes away. Or the owner can post a bond. If the $7,000 lien is filed, the owner can put an $8,000 bond up with the court, and that takes the lien off. And then the guy goes and fights for the $8,000 bond. And so there are all kinds of, trying to explain, there's a whole course on this stuff. But the concept is to understand, and here's the lesson I'd like you to walk out of here with, is that if I'm building a property, if I'm developing a piece of property, and I sign a contract with a contractor, it's my job to make sure that everybody gets paid. Me, the owner, because you can pay twice in Florida. All these notices the owner coming in, I don't care about this. I don't care who the plumber is, tear it up, throw it in the pot. Well, you better care. You better make sure there's going to be a release there at the back end for that plumber, because if he doesn't get paid, he's going to file a lien against your property. He's going to have the court sell your property to get him paid. Yes, Jay?
Yeah, and that was kind of what I was getting at was, you know, say this is a large development, and say that, you know, you put everything into it, you know, and you don't have a lot extra, and a small contractor sues you for, you know, like $100,000 or $50,000 job, and wins.
Are you talking about the GC or the sub?
No, the sub, but in wins, and you haven't finished the project yet, so you have no cash flow or money to pay this guy his lien. Is there a potential that they would make you sell this property before it was finished,
Well,
before you could recoup
candidly,
payments on it?
this guy can only file his claim of lien at the point that his payment was due,
Correct.
and
Well, what if he was
filed a
early in the
notice-
project? What if he's an
Let
architect?
me finish.
Right.
And he's got a year to file suit,
Okay.
and then the lawsuit's going to take him 2 or 3 years. So what I'm saying is, before you get to the position that he's going to have the property sold to pay, a lot of other things are going to happen. This doesn't happen next week and shut down your job. And let me complicate this even further.
Have you heard of a case where, I mean, they do
Oh,
actually
yeah,
sell the land?
Hundreds of variations of all these things have happened. 'Cause have happened. That's why there's so much construction litigation. There's full-time construction litigators. 'Cause have happened. 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 'Cause have But there's another wrinkle in all this that's something we haven't even gotten to yet. The owner probably didn't have any money. He got a construction mortgage. So there's a mortgage in here in front of all this stuff. There's a mortgage recorded. And every one of these subs who files a lien, well, he's behind the mortgage. So if the owner then doesn't pay the mortgage, the lender's going to foreclose and take the property, and it's going to wipe all these guys out, and nobody gets paid nothing. So we're going to start adding layers to this as we talk about mortgages and things like that, and other types of liens, and the priority of liens, and the recording stuff that we talked about. Chad, again, taking for granted that everybody just kind of understood what that was. You're going to learn that the recording order of all of these documents is hugely important. He who records first has the first claim. And to tell you who's going to record first, before any of these guys can do any damn thing, is going to be the lender making the construction mortgage. And he's got the first claim. And so the recording order and all this stuff is going to be a whole concept we'll deal with later. But candidly, in the middle of a job, for the plumber, there were 4 or 5 things that would happen that would stop it. First thing the owner would do would be file a notice of contest. It would say you have 30 days to sue or lose it. Okay? The next thing is, if he does in fact file suit within the 30 days, then the owner or the contractor, either one, would put up a bond, right, and a cash bond, and then he's only suing to recover against the cash bond, but his lien on the property is gone. And once that's happened, he will never have a claim against a piece of property. Remember, his claim, this is not a way to get a piece of property. It's a way to get paid. And once he's getting paid, that's the end of the lien. This is not a method of becoming an owner. It's a method of getting the court to sell the property to get you paid. That's all we're talking about. So there are any number of ways to keep, Chad, from happening what you're suggesting, but it would really happen anyway, but because of passage of time, it would just take too long. But it would never get to that, where some plumber is going to bring a property to the ground. If there's a construction mortgage, they're going to see that he gets paid anyway. Now realize, as we talked about, the situation, we put a construction lender in here. Construction lender's doing all this. Owner doesn't even have any money in the job then. It's the construction lender who's paying the GC in stages. And it's the construction lender who has a huge construction department that monitors liens and notices to owner and all that stuff. They search the title every time they make a payment to see whether liens have been filed. They collect all the notices to owner because they record a document that requires that any time there's a notice to owner filed, it doesn't just go to the owner, it goes to the lender. So the wrinkles in all this stuff is interesting and incredibly complicated. But the lesson, again, is you can pay twice if you're not careful. And secondly, and this is what I think I told you the first day, I hope so, if you get involved in this stuff, this is one of the places you need a good lawyer. Not Joe Blow, the PI lawyer that thought that someday it'd be fun to do a construction job. I'm talking about an expert. There are people who do this stuff and nothing but this stuff, who can spout out the stuff like 45 days for this and 30 days for that and 90 days for that and a year for this, and they know all these things forward and backwards. And like this guy has 90 days to file the claim of lien after the day he did his last work on the job. If he waits 92 days, there is no lien. And he had 45 days to file that notice to owner. If he files it on the 47th day, doesn't matter, too bad, lien's no good. So it's tricky, hairy stuff. Okay, that's the end of my shot on mechanics liens. This is called mechanics liens or sometimes materialman's liens. But they're construction liens. That's what we're talking about. Okay, now, second type of lien. This is how a lien attaches to your piece of property without your consent, is simply somebody gets a judgment against you in a lawsuit. This is called a judgment lien. This is the lien of the winner, of the plaintiff, in a lawsuit against the property of the defendant who loses, or an appeal or whatever. What we're saying here is if you get a judgment against the property owner, you, the winner in the case, can have a lien against his property. Now, there is a horribly misleading statement in the text that says if you get a judgment against a guy in the county where his property is, then you get a lien. Yeah, that's true. But you can get a judgment against him anywhere else too. That's the lesson of all this. If you sue me in Nebraska and get a judgment against me in Nebraska, and you record it here in Broward County, properly go through the steps, it's a lien against my Broward County property. The materials made it sound like you can only have a judgment if you sued me here in Broward County. And of course, sure, if you sued me in Broward County and got a judgment and I have Broward County property, then it's a lien against my property. But you can get your judgment elsewhere too. And easily creates a lien from a judgment, any court in the state of Florida recorded in the county where the property owner owns property is automatically a judgment lien. Now what that means is, it's a lien. Then, the court can have my property sold in order to pay the judgment that I owe you. There's a great comment in the text. I was critical of them saying it implied that it's only in the property, only in the county where the property is located. Yeah, that's wrong. It's much broader than that. But the great comment that I like is it says, when you sue a guy and you get a judgment against him, he doesn't walk over to the next table and open his checkbook and write you a check. Oh, okay, yeah, I'm sorry, sure, here's $20,000. No. It's often much, much tougher to collect on a judgment than it was to get the judgment. In other words, the fact that a court says, I should pay you $20,000, what are you going to do about it? Of course I'm not going to just write you a check. What are you going to do about it? How are you going to get paid? Well, first thing you're going to try to do is see if I own any property here in Broward County. If I do, record your judgment here. If you got your judgment in Broward County, you'll get recorded in Broward County automatically. That's nice. But if you got your judgment in Tallahassee, you want to record it here in Broward County if you find I own some property here. Or if you find I own some property in Pensacola, you want to record it over there too. And this is a lien. This is the right to have a court sell a piece of property in order to enforce the payment of a debt. This is one type of thing. You required improvement to property and stuff like that. That's one type of lien, a construction lien for not getting paid. This is a judgment lien. This can be, and this doesn't have anything to do with that piece of property. This is a PI case. This is, I had an auto accident and I was drunk driving in Georgia. And you get a judgment against me in Georgia. You record it here in Broward County, it's a lien against my Broward County property. And you can try to get the Broward County judge to sell my property to pay your judgment. Because it's a lien against my property. Okay, that's a judgment lien. The parties are called a judgment creditor, obviously. And the judgment debtor is the property owner. Now, I want you to remember, and this is where it comes into play, something we talked about before. Remember our talk about a tenancy by the entirety? And that judgments don't attach to entirety of property? But if the piece of property that I own in Broward County, I own as tenants by the entirety of my wife, let's say you got a judgment against me in Atlanta for drunk driving in Atlanta and running over you and breaking your leg and you're hurt. I owe you $50,000. Georgia, Atlanta court says Steve Genestra owes you $50,000. You want to collect. I'm not going to just write you a check. What are you going to do about it? You're gonna go looking for assets, and we can talk about all, we could, in a different course, talk about all the other ways you try to get paid, to find my bank accounts and securities and but also, you're gonna go looking for a piece of property. Now, let's say you find in Fort Lauderdale a piece of property that I own jointly with my wife as tenants by the entirety. Well, that's tough. Record your Georgia judgment here. It's not a lien against property I own jointly with my wife as tenants by the entirety. Or maybe it's my home. It's homestead. Homesteads are exempt. Can't touch that either. So, this is not an automatic lay-down, is what I'm saying. And of course, whereas we're going to talk about recording priorities down the road, and if I already have a mortgage on the property and you record a judgment against me, well, you're after the mortgage. And if I don't pay the mortgage, they're going to foreclose and wipe you out anyway. So this is not as simple as, in any event, oh, okay, I'll just write my check. Yes, ma'am.
What if they go and buy more properties?
Say what? I'm sorry?
If you go and buy more properties, and we still.
Sure, as long as that judgment is a record, it's a lien against all property. We're going to talk about 2 seconds. Recording of a judgment in Florida is a lien against all of the property of the judgment debtor for 10 years. Either currently owned at the time you record it or acquired in the next 10 years. And at the end of 10 years, that judgment lien expires, it can be re-recorded for another 10 years. So for up to 20 years, it's a lien. Your Georgia judgment against me is a lien against all property that I own in that county now, or for the next 20 years, conceivably 10 and 10. But not property owned as tenants by the entirety, or my homestead. And if I own 20 pieces of property worth $100 million, and your judgment's only $50,000, that's fine, it's a lien against all of them. Until you get paid. You only get to get paid once, but it's a lien against all properties. Okay. Now, it's in order to create this lien, you have to record a certified copy of your judgment in the same public records we've been talking about. The same place where you would file a claim of lien, where you would file a deed, where you would file a mortgage, where you would file anything. You get a certified copy. All that means is some clerk puts a little seal at the bottom and says, yeah, this is a certified copy. Kind of a fancy quality copy. You got to record it in the county where the property is located. And you'll see how this all ties into title exams later when we go look at titles. In other words, if I'm buying a piece of property from you, if you're buying a piece of property from me, you want to know if there are any judgments recorded against me. If you're buying a piece of property from me in Broward County, you really don't care if there are any judgments recorded against me in Dade County. But you care about judgments recorded in the county where the property is located. Those are liens.
They stay with the property, correct?
I'm sorry?
They stay with the property.
Until they've been paid or until they expire, which is 10 and 10. But they're a lien. That still doesn't mean that I got to write you a check. It means you have the right to ask the judge to sell the property to get you paid. But if you do nothing for 10 years, poof, it's gone. But it's going to make it very difficult for me in the next 10 years to sell it or to get a mortgage on it. Because the buyer fears you might do something now. And it stays with the property. It stays with the property if it gets transferred 5 times in that 10 years. It's still a lien on the property. And you can take that action against, if I sell it and then he sells it, you can take that action against that guy and foreclose a lien against his property because it was on there and stayed on for that whole period of time. Just like a mechanic's lien would stay on. It only stays on for a year. Or a 50-year mortgage would stay on for the 50 years no matter who it's conveyed to. Okay, so that's a judgment lien. Now, there are 2 quickie concepts I want to talk about because I want you to be familiar with these terms that relate to a judgment lien but are not a lien. And the first one is a notice of lis pendens. Notice of lis, L-I-S, pendens, P-E-N-D-E-N-S. And that means a notice of litigation pending, lis pendens. And all that is simply this. Forgetting all this construction crud. If you're suing me and I own this piece of property, you can file a notice of lis pendens that says, I want the world to know that I'm suing the owner of this piece of property. And anybody who takes a deed or a mortgage is subject to the outcome of my case. It's like a warning. It's warning to the world, I'm suing this guy with a matter that relates to this piece of property. And if you buy from him or take a mortgage from him, you are subject to the outcome of my lawsuit. Now, if I lose, no harm done. But let's say I had a sales contract with this guy, and I'm going to sue him now to get my deposit back. I want to file a notice of lis pendens that tells everybody, don't buy this piece of property from him until my deal is concluded, because I may have a claim against this piece of property. It's not a lien yet, because you're not entitled to any money yet. But it's notice of the pendency of a lawsuit that might affect the title of a piece of property. That's a notice of lis pendens. That's the right to file a notice in the public record saying, I'm filing a lawsuit that may affect the title of this piece of property. There's one other thing. It's a greater step, and that's called an attachment. And an attachment is a pre-judgment lien where you say to the court, Your Honor, I want you to grab this piece of property and hold on to it for me because I've had a claim against this guy, and I want you to hold this piece of property in case I'm successful. That's really rare. It's hard to get because, of course, the courts are saying, like the innocent until proven guilty thing, what do you mean, we're going to grab this guy's piece of property and tie it up for 3 years during this litigation, and you may not even win? So here's what the courts require you to do. Post a bond. You have to, if the property is worth $100,000, you have to post a $110,000 bond to protect this guy because you screwed up the title of his property in case you're wrong. So it's an expensive concept, but it is possible to attach a piece of property. Now, I want to talk about a couple more quickies, types of liens, and then we're done. There's a vendor's lien. The vendor is a seller. A seller has a lien against a piece of property he sells in case he doesn't get paid. And that's a lien prior to anybody. Seller sells a piece of property and takes a bad check. He ain't been paid yet. That's a vendor's lien. Seller's lien. Now, we're going to talk about financing, and we're going to talk about mortgages, and we're going to talk about the seller taking a mortgage back, maybe. If the seller takes a mortgage back, that's different. He has a mortgage. He has a recorded mortgage. This is plain old, like in a cash deal. The seller didn't get paid. It's a vendor's lien. The seller has a lien against a piece of property that he sold until he's been paid, unless he agreed to take financing, and that's different. Then he has rights under whatever his financing contract was. But this is plain old, my cash money. Okay, that's a vendor's lien in favor of a seller. That's another type of lien. There are the materials say they're parts of the same thing, but I say there's something different. Is real estate taxes is the first. The lien for real estate taxes. Your annual ad valorem real estate taxes are a lien against the piece of property. in favor of the governmental entity that levies them, Broward County. Okay? Your county annual real estate taxes. They are the highest lien priority allowed by law of anybody in anything. They're in front of mortgages. They're in front of contractors. They're in front of judgment liens. They're in front of vendors' liens. The point is, annual real estate taxes have the very first lien claim against a piece of property above anybody for anything. The point is, the government's going to get paid. And that's because this is what funds your police and your schools and your utilities. And everywhere, every state in this country, annual real estate taxes are the highest priority lien. That's why lenders want to be so damn sure they get paid, because even if a lender forecloses a mortgage, takes the property, got to pay those taxes. I'm sure some of you have had mortgages on homes and lenders have escrowed your taxes. Escrow, lender makes you pay your taxes 1/12 every month along with your mortgage payment, because they want to pay your taxes, because they want to be so damn sure the taxes get paid. So annual real estate taxes are the highest lien priority there is. What happens is, just so you'll know, if they don't get paid, just a 10-second walkthrough. In Florida, you get a bill for this year's taxes in November. If you don't pay them by next March, you're delinquent. If you don't pay them by May, the government has what they call a tax sale certificate auction. And in May, next May, for the 2015 taxes, in May of 2016, the government will have an auction. And people will come in and bid for the right to be able to pay the taxes on your piece of property. And they will pay those taxes, and they will hold what's called a tax sale certificate for 2 years. And for 2 years, as the owner, you still have the right to pay them back with interest. And at the end of that 2 years, they walk into the county tax collector, and he gives them a deed to your piece of property. Now that deed wipes out all the liens, all the mortgages, all the claims, all the everybody, because taxes are the first lien, period. So about 3 years after you didn't pay your taxes, whoever did pay them for you has got your piece of property. And he's got it without any mortgages on there. So lenders are real interested in all this. That's why lenders make damn sure every year you paid your taxes. Because even if you're paying them and they're happy as a pig and you know what, sitting back getting their payments every month, they can lose the property because you didn't pay your taxes. So you pay the lender and the lender pays the taxes, and that way they know they get paid. Yes?
You mentioned you paying back with interest you have the right to. Who sets the interest rate?
That's what, believe it or not, that's what the auction is all about.
Okay.
The guys at the auction say, depending on the value of this piece of property, I'll pay the taxes on this piece of property for only 3%.
Oh, so you basically bid.
And the other guy says, I'll pay them for 2.5%. Government doesn't give a damn. Government gets the taxes paid.
That's funny.
So that's how you bid, because there's only a certain amount of taxes due.
Well,
The taxes on this property were $1,000. The owner didn't pay them. Next May, people come in and want to have the right, maybe, to get that piece of property someday, because this is a pretty cool piece of property. Now, if it's a piece of crap, people say, I bid 20%.
That's why I'm asking, because I was in the county auction site looking at the taxes.
Yep.
And I saw interest rates like at 14, 15%. I saw some at 2%, 3%. So I was just wondering.
It's based on the value of the property. Is it a good property is it a good property I'd like to have? If they're bidding 2 or 3%, it's a very valuable piece of property. They're probably going to get repaid.
Yeah.
But there's that little chance. Things happen like in estates, people die and the
No,
heirs
of
forget
course,
to pay them and
it's
stuff like that, and they don't realize all this is going on because the heirs are in Nevada and Hawaii and they don't have any idea of all this stuff, and they don't pay the taxes for a few years. That piece of property's gone.
No,
It's over. And somebody who bought it at the auction, you know that the amount is only gonna be 2 or 3% of the value loosely is what the year's taxes are gonna be. But is it a good piece of property or is it a piece of junk? You
Yeah.
know? Sometimes the taxes are on a right of way under a bridge. Who
Yeah.
wants it, you know?
Of course.
So if that's the case and you're looking, you don't really want the piece of property, you're gonna want a lot larger return.
Of course.
So that's what people are bidding. There's only $1,000 due, and it's who gets to write the check to the government for $1,000? How little am I willing to earn for the next 2 years for the owner to pay me back? And at the end of that 2 years, I get to come in and ask for a deed. Now, it's not quite that simple. Then the government sends a notice to everybody. Then the government sends it one more time to the owner, I'm about to deed your property. One more time to the lender, hey, you got a mortgage on here? I'm about to deed the property. So somebody can come running in and pay him back. But if you go through all those hoops and nobody ever pays, you got it.
Right, even if you pay it back, you're still getting paid back with good interest.
Yeah, I mean, it's a very good investment. If you buy a tax sale certificate, you're going to get paid either whatever rate you wanted plus a bunch of costs and credit, or you're going to get that piece of property, one or the other. But it may be a piece of crap, you know. Okay, one more type of lien and we're done. Federal tax lien. You owe the federal government money. You didn't pay your income taxes. Didn't pay your estate taxes. Didn't pay your employee withholding taxes. Usually they're income taxes. Money's owed the federal government. They don't have to go to court and get a judgment against you and record it like a judgment. They get to just file a lien. Federal tax lien. Good for, I think it's 6.5 years. Usually you find a guy's social security number in there, because usually it was income taxes. Usually they found them about 2 or 3 years after. In other words, they'll send a notice to the guy, hey, we didn't get a tax return from you for 2010. And that's in about 2012. They catch up with and say, hey, we didn't get a return from you in 2010. And then a year or two later they say, okay, well, based on your income the last couple of years, we think you probably owed us $20,000. So we're going to lien your property for $20,000 if you don't pay us. And he still doesn't. So usually maybe about 2014 or so they file a federal tax lien against, this is like a judgment. It's a lien against all property owed by the taxpayer in whatever county it's recorded in. So remember that some of these things are site-specific. This is, if you'll forgive my making up the term, this is site-specific as to this piece of property. I did work on this piece of property. I want to lien on this piece of property. But if this guy didn't pay IRS, or if somebody got a judgment against him, it's a lien not only against this piece of property, but his piece of property over here, and is also his piece of property over here, wherever it's recorded, in the county where it's recorded. So, the federal government knows where you are, and they get to record free. They don't pay the $10 a page like the rest of us do, so they just file a federal tax lien in all counties in the state of Florida. Maybe he has something somewhere in Florida. They don't go research and find out. They just plain old file a lien everything. And it's a lien against all your property for 6.5, 7 years, something like that. Yes.
Okay,
Which
so-
means the federal government has the right. And they don't, let me take that one step further. They don't have to do what the rest of us have to do. They don't have to go to a local judge and say, Broward County Judge, would you please have a sale of this property to get me paid? They just advertise and issue a deed themselves. Hi, we're Uncle Sam. Joe Blow didn't pay his income taxes. Would you like to buy a deed from us? And people come roaring in and buy it. So they just plain old, after they file their lien ties up your property for 6.5, 7 years. But after a few years, they decide, we think we'll just sell it. And they advertise it, and people come in and pay them, and they have an auction, and people bid, and then they hand out a deed to somebody. And it works. It works because they are the sovereign, and they're the biggest sovereign. And they can take it away from everybody who's recorded the property locally. Now, I mean, everybody who has local claims against the property, because IRS comes first. Now, but not in front of real estate taxes. Whoever buys that property from them, we'll still have to pay whatever back real estate taxes are on. Uncle Sam never pays real estate taxes, but Uncle Sam doesn't get to wipe out real estate taxes either. So if you buy something from IRS in an auction, the taxes haven't been paid for 6 years, you're gonna have to pay those taxes. Or else they'll have their own tax sale certificate and they'll take the property away from you. But, yes, now, did I?
Two questions.
Yeah.
So will the federal tax lien go away will the federal tax lien go away if you buy the real estate taxes? What if you have two liens from the federal and the real estate taxes?
Okay. The real estate taxes, the title will go to whomever buys that tax sale certificate and doesn't get paid for 2 years and goes in.
So you will cancel the federal tax on that?
Yes, that would cancel the federal tax lien.
Okay, another question. How do you find all the liens that's on a particular property?
You go search, you examine the title. We're going to talk about that next week.
Also-
You examine this public records I talked to you about, where you go record all this stuff.
Yeah.
You go read about it.
So what if
That's
it's
called
not?
title examination, and that's a topic for next week. You examine the title to see how many mechanics liens are there, how many mortgages are there, how many judgments are there, how many tax liens are there, who owns it, has he paid the real estate taxes? You go get all that information before you close. When you sign a contract to buy a piece of property with somebody, there was a paragraph in the contract that we talked about, where we said, you're going to examine the title to the property after you sign the contract, but before you have a closing. You're going to go research all of this information to find out what all those liens are. Because if you don't, and you buy the property, and you get a deed from that guy, all those liens are still on there. And then they're going to either take it away from you, or you're going to have to pay them. So there is a method to find out all this stuff. It's called title examination. And that's why all these people do go record, because they'd like to get paid.
What if it's not record? What if somebody didn't get there at the time to record it?
What if what? I'm sorry.
If it's not recorded?
So if it's not recorded, then
It's not recorded, you missed your boat, you missed your claim. In other words, if this guy sells me this property and I record my deed before this lien ever got filed, this lien is no good. He has to file his lien while he is still the owner. Okay?
Okay.
Now, that's an oversimplification, because you can miss that by a day or two and there are exceptions, but oversimplified. However, nobody with half a brain would buy a property from a guy in the middle of a construction job, would buy a half-finished house with workers out there every day, because he doesn't want to buy into the middle of this mess. We'll see who's paid and who's not paid. So realistically, that doesn't happen. You know, realistically, people don't buy a piece of property without seeing it and seeing there's a construction job going on. But what they don't see is they don't see that whether or not the taxes are. When you drive by and look at this piece of property, you don't know whether the taxes are paid. You don't know whether there are any federal tax liens filed against this guy. You don't know whether there are any judgments filed against this guy. You really don't know whether there are any liens filed yet until you search the title. But these things don't, you know, they don't put a sign out front that says IRS has a lien here. They just record in the public records, and if you buy it, all those liens are on there, and they can take it away from you. Yes, ma'am.
So federal tax lien is recorded against the taxpayer or against the property?
Well, against the taxpayer,
Who owns the
but
property?
it is a lien against all of the taxpayer's property,
All of it.
wherever located. That's one of those things I talked about is non-specific as to a certain piece of property. It's very specific as to who the taxpayer is, but it's not specific as to which piece of property. All of his property wherever located. Just like a judgment lien. Wherever you record it though. A judgment filed in Broward County against this guy is not a lien against his Hawaii property. But you gotta file it in Hawaii, then it's a lien against all of his Hawaii property. So you only have to search the title, as we'll talk about, where the property is. See if something's recorded there. You don't have to search the title in Hawaii to Florida property to see what is anything recorded in Hawaii. Nor do you have to search in Dade County either, or Palm Beach County. You have to search in Broward County. Sounds real simple. There are how many gazillion documents recorded in Marion County, but only the county where the property is located. Because only those can create liens against property in that county. Okay? I know everybody's hungry, let's go lunch. So what time is it? 10 after? What does it say?
1:10.
All right, let's start back at 20 minutes up, 22 of, something like that. See you then.
You have to go to the library and register.
Yeah.
And then there's a guest
I got
room.
mine now.
I connected with the guest. With the guest.
Anything to do with
here? Verifying the day.